Chapter 4 of UCC Sales talks about the contract formation. 1. Introduction. This chapter reviews the typical patterns of contract formation that UCC Article 2 addresses. The UCC defines a contract as the total legal obligation that results from the parties' agreement. It is necessary to see how a contract was formed to determine the rights and obligations of the contracting parties. Accordingly, after you determine that Article 2 governs the analysis of a particular transaction, it is then necessary to assure that the parties have exchanged legal obligations. Figure 4-2 links Article 2's basic contract formation provisions. So, 2 boxes stem from contract formation. There's question 1, is there a contract? And generally, any manner sufficient to show agreement yields a contract. In specific situations, a firm offer by a merchant followed by an acceptance is discussed in 2-205. An offer followed by shipment of conforming or non-conforming goods in 2-206, and an offer followed by deviant acceptance in 2-207. For the other part of the diagram, post-formation issues, there's contract modification discussed in 2-209 and assignment and delegation in 2-210. In the general column, the citation is 2-204, defining any manner sufficient to show agreement generally forms a contract. 4 code sections contain the basic contract formation rules. Section 2-204 states the general rule, and the 3 sections that follow state the rules for specific situations. The sections that students need to link up, the definitions students need to understand, the material in this chapter are set forth in figure 4-3, which is the next figure. For definitions of agreement, see 2-204. Also, 1-201. So, in fact, Article 2 is citing 2-205 is citing what's in Article 1, defining merchant, sign, writing, reasonable time, and assurance in those respective places. Likewise, 2-206, which, if you remember, stood for offer followed by shipment of conforming or non-conforming goods, refers to conforming as defined in 2-106 and non-conforming. For 2-207, an offer followed by deviant acceptance, the cross sections that are relevant is to define definite and seasonable expression of acceptance, additional or different terms, material alteration, and undue surprise or hardship. Wow. 2-208 is going to use course of performance, express terms, and implied terms in definitions. The interpretation of 2-209, which talked about a contract modification, will rely on definitions of modification, rescission, and waiver. And 2-210 about assignment and delegation will rely on those definitions. Part 2, contract formation in general. Section 2-204 is a general provision that recognizes that a contract can be formed relatively informally. Section 2-204 applies whether or not one or both of the parties to the alleged contract are merchants. Historically, one of the most common ways of forming a contract was through the process of offer and acceptance. The UCC does not define an offer. Accordingly, students must analyze whether an offer was made using the common law definition. Under Restatement Second of Contracts, Section 24, an offer is the manifestation of willingness to enter into a bargain, so made as to justify another person Another person. Okay, offer is the manifestation of willingness to enter into a bargain so made as to justify another person in understanding that his assent to the bargain is invited and will conclude it. At common law, an acceptance is the manifested willingness to enter into the same bargain. Furthermore, for a contract to be found, definite terms are required. Section 2-204 liberalizes the common law's rigid requirements of acceptance by providing that a contract can be found even though the time of making it is undetermined and even though some terms are missing. I am skipping a case called Corona Oro Inc. versus Harry Thompson. And moving to part 3 of chapter 4, the role of merchants in contract formation and throughout article 2. Part 3.1, who are merchants. One of the most important concepts that article 2 introduces is the idea that people who are professionals in business should be held to a higher or at least a different standard when they deal in goods than people who are not professionals. The code names professionals merchants and defines merchant in section 2-104. Official comment 2. So section 2-104 explains that merchant status embodies the concept of a professional in business and that the professional status may be based on specialized knowledge as to the goods or specialized knowledge as to the business practices involved in the transaction. Figure 4-4 shows the different ways that people may be classified as merchants. Dealer, knowledge or skill, and by attribution. The definition of dealer is a person who deals in goods of the kind. Knowledge, there's examples also. Knowledge or skill is defined as a person who otherwise, by his occupation, holds himself out to be having knowledge or skills peculiar to the practices or goods involved in the transaction, and by attribution, a person to whom such knowledge or skill may be attributed by his employment of an agent or broker or other intermediary who, by his occupation, holds himself out as having such knowledge or skill. Students will find it easy to recognize a merchant who deals in goods of the kind. Any seller whose business is selling goods is a merchant who deals in goods of the kind when that seller is selling the goods he normally deals in. Thus, an office supply store is a merchant who deals in goods of the kind when it sells any of the office supplies it normally sells. Keep in mind that a seller will not be a merchant who deals in goods of the kind when it sells something it does not ordinarily sell. For example, if the office supply store does not normally sell cars and it decides to sell one used car that it has used in its business, it will not be a merchant who deals in goods of the kind in the used car sales transaction. The next type of merchant is sometimes harder to recognize. There are actually 2 ways that someone can be a merchant because he otherwise, other than by dealing in goods of the kind, by his occupation holds himself out as having knowledge or skill. Specifically, he may hold himself out as having knowledge or skill with respect to the goods involved in the transaction, or 2, he may hold himself out as having knowledge or skill with respect to the business practices involved in the transaction. Official comment 2 explains that the type of specialized knowledge that is sufficient to establish the merchant status is indicated by the nature of the code provisions. It explains that for purposes of certain provisions in Article 2 that dealt primarily with normal business practices which are or ought to be typical of and familiar to any person in business, for purposes of these sections, almost every person in business would therefore be deemed a merchant under the language who, in quotes, ... by his occupation holds himself out as having knowledge or skill peculiar to the practices ... involved in the transaction, end quote. The last type of merchant is a merchant who is treated as a merchant because he employs someone who has the requisite skill or knowledge with respect to a particular transaction. Official comment 3 gives, as an example, a university, which may be a merchant by reason of its employment of people in the purchasing department who are familiar with business practices and who are equipped to take any action required. Section 3.2, Special Article 2 rules that apply only to merchants. A significant number of sections of Article 2 contain special rules that apply only to merchants. Some of these sections apply only between merchants. Official Comment 2 to Section 2-104 arranges these code sections into the categories shown in Figure 4-5, normal business practices, merchant plus requirements, and general goods and practices. So normal business practices, in parentheses, it says paperwork provisions are applicable to practices merchants sections 2-201, 2-205, 2-207, and 2-209. Merchant plus requirements, in parentheses, it says different standards for merchants, are applicable to goods merchants sections 2-3123, 2-314, 2-402, 2-4032, and 2-509-3. General goods and practices applicable to both practices and goods merchants. Sections 2-327, 1C, 2-103, 1B, 2-603, 2-605, 2-509, 2-609. And then there's an exercise on who is a merchant. Sets forth lots of questions and answers we answered in class. Subsection 4, contract formation specific rules. The 3 sections that follow, section 2-204, each address a narrower set of facts under which a contract can be formed. For instance, 4.1, contract formed by merchant's firm offer followed by an acceptance. Section 2-205 defines a firm offer. One way to attack this section is to try to find the parts of the statute as we discussed in Chapter 2. Figure 4-6 on the next page takes this approach. This section is easily deconstructed into the following elements: an offer by a merchant to buy or sell goods in a signed writing that by its terms gives assurances that it will be held open. Those are the elements of a firm offer. It is easy for someone familiar with sections 2-205 to write a firm offer. For example, a merchant may include the following language in an offer letter to purchase or purchase order. This is a firm offer under section 2-205 of the Uniform Commercial Code and will remain open for blank days from date. To determine whether a particular offer is a firm offer, each element of section 2-205 must be analyzed separately. First, because the UCC does not define an offer under section 1.1-103, you can use the common law definition of offer for your analysis. Next, you must apply the code's definition of merchant. You will already have analyzed whether goods are involved in your scope analysis. The language of 2-205 seems to limit the applicability to actual sales of goods because it uses the language to buy or sell goods. If you want to determine that there is a firm offer when a sale is not involved, you will need to argue policy. The next element is the requirement of a signed writing. Both the terms signed and writing are defined in Article 1. Look up those definitions. Now, what if a merchant posts what appears to be a firm offer on his website? Will that format satisfy section 2-205 requirements for signed writing by UETA or eSign? Help with your analysis. The final requirement for a firm offer is that the offer itself gives assurances that it will be held open. The actual language used in the offer must be interpreted to determine whether this element is satisfied. Section 2-205 specifically displaces the common law rule that provides generally that an offer can be revoked at any time before acceptance unless the offeror receives consideration to hold the offer open for a period of time. If the elements of section 2-205 are satisfied, The results under the statute, the operative provision is that the offer is not revocable for the time stated, or if no time is stated, for a reasonable time. The maximum period of irrevocability is 3 months. Section 2-205 contains a special rule for a firm offer when the offer is made on a form supplied by the offeree. In such cases, the term of assurances must be separately signed by the offerer. Official Comment 4 explains the reason for this special rule. Students can best understand the rule and its underlying rationale if they picture a purchaser of goods who has significant clout, such as Microsoft, Boeing, or other companies who purchase goods. Such companies often require vendors to present purchase orders using the big company standard form rather than the vendor standard form. Thus, when the vendor submits a purchase order using the big company standard form, the vendor's offer will be on a form supplied by the offeree. In that case, for the firm offer provision to bind the vendor, the offerer, the vendor must separately sign that provision. And I think this is the battle of the forms that they're talking about. Figure 4-6 comes next, finding the parts of a statute on firm offers. This again goes through the purpose, scope, exclusions, definitions, and operative provisions and consequences. There's another, followed by another exercise. Moving right into section 4.2, contract formed by shipment of conforming or non-conforming goods in response to an offer. Recall that at common law, courts construed offers as creating a power of acceptance. As you remember from your contracts course, distinctions between unilateral and bilateral contracts requirements of notice of acceptance and similar issues were often dispositive on an issue of contract formation. The UCC addresses these topics in Section 2-206. Section 2-206 covers a range of topics. First, Section 2-206, 1A liberalizes the common law mirror image rule that requires an offeree to respond to in the same manner and medium as required by the offer, and provides Jalen Hurts just got a touchdown. Yeah. Provides instead that unless unambiguously indicated in the offer is construed as inviting acceptance in any manner and by any medium reasonable in the circumstances. Second, Section 2-206.2 addresses the common law issue of whether notice of acceptance of an offer to form a unilateral contract is needed. Perhaps its most significant provision, however, is Section 2-206.1b, which specifically changes common law rules regarding shipment in response to an offer. You may recall that at common law, if a buyer made an offer to buy goods and the seller shipped different goods in response to that offer, a contract was formed on the seller's terms because the seller's shipment was treated as a counteroffer which the buyer accepted by accepting the goods. No contract was formed until the buyer accepted the goods. Accordingly, if a seller did not ship goods in response to the buyer's offer, there was no breach of contract because there was no contract. Under Section 2-206.1b, the seller can still prevent contract formation if it fails to respond to the buyer's offer at all. However, if the seller ships goods in response to the offer, whether or not the goods are conforming, the seller's shipment of goods is treated as an acceptance of the buyer's offer. So a contract is formed on the terms of the buyer's offer. And because the contract formed is on the terms of the buyer's offer, if the goods fail to conform, the seller is in breach of contract. To avoid this result, Section 2-206.1b permits a seller who wants to avoid liability for breach of contract to ship non-conforming goods as an accommodation, in which case the shipment of goods will be treated as a counteroffer and non-acceptance. Under those circumstances, if the buyer accepts the goods, the contract is formed on the terms of the seller's counteroffer. And the next exercise is a case. Corinthian Pharmaceutical Systems, Inc. versus Ladera Laboratories. That starts on page 54. And I'm going to move to section 4.3, contract formed by deviant acceptance of offer. Section 2-207 is known as an attempted statutory solution to the battle of the forms. This often misunderstood section is poorly written. Students should carefully deconstruct the statute one subsection at a time before trying to apply it. Deconstructing Section 2-207 is a daunting task. First, it is important to understand that what each subsection does and does not do. Following is a brief overview of each subsection in words and graphics, followed by a more detailed discussion. And figures 4-7, 4-8, 4-9, and 410 depict what the statute is trying to say, not exactly what it says. Be sure to read the statute out loud as you review the figures to assist you in translating the statute. So subsection 2-207 involves only one question: is there a contract? It deals with two distinct fact patterns. The first situation is where the parties first form a contract, usually orally, and one or both of the parties follow the contract formation by sending a written confirmation to the other within a reasonable time. If that written confirmation contains additional or different terms, Section 2-207 confirms that Section 2-207 governs the analysis of the fact pattern. So this is really defining all of these figures, etc., is a way of defining additional terms and different terms. And that's very nice. But and then it's followed by several exercises. So since this is about 3 pages of deconstruction and filling in the statute with definitions, I am going to read section 2-207 and move on. Additional terms in acceptance or confirmation. 1. A definite and seasonable expression of acceptance or a written confirmation which is sent within a reasonable time operates as an acceptance, even though it states terms additional to or different from those offered or agreed upon, unless acceptance is expressly made conditional on assent to the additional or different terms. Part 2 under section 2-207. The additional terms are to be construed as proposals for addition to the contract. Between merchants, such terms become part of the contract unless A, B, or C occur. A, the offer expressly limits acceptance to the terms they offer. B, they materially alter it. Or C, notification of objection to them has already been given or is given within a reasonable time after notice of them is received. Third, under 2-207 is conduct by both parties which recognizes the existence of a contract is sufficient to establish a contract for sale, although the writings of the parties do not otherwise establish a contract. In such case, the terms of the particular contract consist of those terms on which the writings of the parties agree, together with any supplementary terms incorporated under any other provisions of this act. So for a really nice marked up figure, turn to page 65 for more on what is meant by deviant acceptance to the contract formation. I'm going to move on to the last couple of pages. Contract modification, section 4.4. Students sometimes wonder why the topic of contract modification is included in this chapter on contract formation. The short answer is that part 2 of article 2 is entitled Form, Formation, and Readjustment of a Contract, and this book follows the order of the code. However, if you reflect on the question, you will realize that many of the same issues that arise in connection with contract formation arise in connection with attempted contract modification. For example, at common law, a basic rule is that consideration is required to make a contract enforceable. Common law also requires consideration to make a modification enforceable. Contracts are generally formed through the process of offer and acceptance. Similarly, parties often arrive at contract modifications through the process of offer and acceptance. Accordingly, it makes sense to study the topic of contract modifications in connection with our study of contract formation. Section 2-209 is the Code's black-letter law on contract modifications. It is relatively straightforward. Subsection 1 specifically displaces the common law rule that requires consideration. It states, an agreement modifying a contract within this article needs no consideration to be binding. Subsection 2 validates a contract clause, commonly known as no oral modification clause. At common law, even when parties' contracts provided that the contract could only be modified in writing, courts uniformly held that an oral modification could be enforced so long as there was consideration for the change. Subsection 2 provides that such a provision will be enforced with one exception, in an exception that parallels the exception in the merchant firm offer provision. Subsection 2 requires that a no oral modification clause in a form prepared by a merchant and signed by a non-merchant must be separately signed by the non-merchant to be enforceable. And subsection 3 requires compliance with the statute of frauds for a contract modification. Finally, subsections 4 and 5 codify common law rules regarding rescission, waiver, and retraction. Because the most common issues raised by contract modifications are issues of good faith and issues of compliance with the statute of frauds, problems involving contract modifications are included in Chapter 5 on contract defenses rather than in this chapter. Section 4.5, third parties, assignments, and delegations. Section 2-210 states the basic rules for assignment and delegation. To understand the rules, it is important to understand the context in which the rules apply. Both assignments and delegations involve a party who is not the party of the original contract. This party becomes involved sometime after the original contract is formed. The original contract does not contemplate performance by or to that party. Subsequently, one of the original contract parties seeks to transfer his rights and/or duties under the contract to a third party. This third party is known as the assignee or delegatee. The terminology used to discuss the topic is explained in figures 4-14 and 4-15. So the assignor is the one who makes the assignment. The assignee is the one who receives the assignment. The obligor is the one who will be rendering performance of the subject matter of the contract. The party was obligated to perform, in other words, and the obligee is the one who will receive performance of the subject matter of the contract at the time of contract formation. The obligee is the party who is the assigner of the assignment. After the assignment, the obligee is the assignee. There's another graphical portrayal of this on page 70. Likewise, figure 4-15 goes through the parties again, but the parties to a delegation, whereas what I read only a moment ago was assignment parties. So delegation parties, the one who is obligated to perform is the obligor. The delegator is the one who delegates the duty to perform, who is the same person as obligor. The obligee is the one who is to receive the performance that is the subject matter of the contract. The delegatee is the one who receives the delegation and is now obligated to both the delegator and the obligee to perform. Again, figure 4-17 sets forth what that looks like in a graphic portrayal. Basic rules under section 4.5.2. Now that you understand who the parties are, read section 2-210 and its official comments. As you can see, most of the rules that you learn in common law contracts remain the same under the code. Official comment 7 emphasizes that the section is not intended as a complete statement of the law of delegation and assignment, but is limited to clarifying a few points doubtful under the case law. The general rule is that contract rights are assignable and duties are delegable. The exception to this general rule is that rights cannot be assigned where the assignment would materially change the duty of the other party or increase materially the burden or risk imposed on him by contract or impair materially his chance of obtaining return performance. Such situations are relatively rare. Similarly, the general rule is that duties can be delegated unless otherwise agreed or unless the other party has a substantial interest in having the original promisor perform. Because the code favors free assignability, clients are well advised to respond to an attempted assignment or delegation with a demand for adequate assurances or performance as stated in Section 2-2106 and discussed in Chapter 11 Infra, rather than treating the attempt as a breach of contract. And that's it for contract formation, Chapter 4 recording.